And the question is that part 2 stand part. I call Materia Ture.
Thank you, Mr. Chair. One of the issues I raised with the Minister late last week was the definition of a returning offender in Clause 7. Now, the whole point of the returning offender sections in this is to capture personal information, name, address, date of birth, fingerprints, of people who have committed an offence in Australia and have been deported. Now, in the description of this, the rationale is that they have been convicted of an offence in Australia that would be an imprisonable offence here and have been deported because of that offence, but that's not what the definition says. And so I would like to just get some clarity from the Minister about how this definition of a returning offender came about, and particularly the extent to which it captures people that really there is should be very little public concern about, so people who don't pose a risk of any kind, and so therefore it's unjust to require this additional information from them by the police. So a returning offender is defined as including a returning prisoner, but that's irrelevant for this discussion. It's a person who's been convicted in an overseas jurisdiction of an offence that would constitute an imprisonable offence here. So it's a similar offence to what we'd have in New Zealand that would lead to the imprisonment, or at least has a sentence of imprisonment. And then it goes on to say, and being liable for deportation or removal as a result of the conviction has returned to New Zealand. It says being liable for deportation or removal as a result of that conviction, not being deported or removed as a result of that conviction. So I just want to get some clarity around those cases. There may well be people who are being deported from Aussie because they fail a different part of the good character test. And there's lots of examples of that. For whatever reason, the minister over there decides they don't like them and they want them to be sent back here. And it's got nothing to do with any previous convictions. They may well have been convicted of an offence 20 years ago, 25 years ago, 10 years ago, 40 years ago. Convictions that actually don't have any genuine relevance, don't pose any risk to New Zealanders. The person may not have been convicted of anything in the ensuing 40, 20, 10 years. And there's no evidence that they pose any genuine risk here. But because they have a conviction in Aussie, it makes them liable for deportation. And so therefore they are caught by this bill. And so I asked the Minister if we could find some ways to constrain this definition more so that minor historical offences for which there's, it's pretty clear that this is a person who's been kicked out under the ridiculous rules of Australia as opposed to actually for a sensible reason, that those people aren't caught by this legislation, that there's no need for them to be caught. They don't pose any risk to New Zealand society. There is a degree of discretion in Clause 8 and 9 by the police in seeking identifying information. But as we know, there's not always a great deal of trust in the police and their ability to use this kind of discretion wisely. For those of us who've been involved with the Māori community for many years, we know that Māoris tend to be targeted, and so we want to be able to protect particularly those who may not have a relevant conviction in the sense that it poses any kind of genuine risk, very minor, very historical, but may be subject to other kinds of profiling by the New Zealand police that are then subject to this law. And there's no protection for them here. This definition of returning offender captures practically everybody who will be deported if they have any kind of conviction in Australia, no matter how historical. The key part of this key point is that it then means that the definition of returning offender is largely dependent on the definition, on the criteria that Australia sets for deportation. It's not an independent criteria that we've set here based on our own assessment of what constitutes a genuine risk of recidivism or a potential threat. The law is premised on Australia's definition of what qualifying offences. And frankly, I have no interest in Australia's definition. Their law is a disgrace. It is contrary to human rights. Their law explicitly says that all rights of natural justice don't apply. So I would like some of this addressed if that's possible, Mr.
Jacinda Ardern.